Mr. Presider, we've completed the plaintiff's testimony. Because this is a Christian proceeding, I understand the case seems right when anyone presents it. We want to try to be fair to NAMB, even though they're not here. In the civil court, as you know, if they didn't show up, they can't testify. But we want this proceeding to be better than that. And so I've asked ChatGPT to write me a neutral summary, given the documents and some of the facts that NAMB has put into the record. And so I'd like to read that to the jury, just so nobody can say you didn't hear anything from NAMB. So this is what they would have said. And we will provide you with some exhibits that substantiate this. We've got some of their pleadings, so you can see, if you'd like to, in the deliberation room, some of the things they said. But we're going to give you 4 exhibits. One is the answer and affirmative defense. So it's their answer.
Who's saying what you're reading?
This is, we've drafted a summary of what we understand. If NAMB were here today, what we think they would say, because it's what they've told the court in the past. I did ask it to write me a neutral summary, yeah. I have edited a little bit to make sure it's correct, yeah. So we're going to give you Proxy Defense Exhibit 1, which is NAMB's answer and affirmative defense. So that was filed in federal court, and that contains their official denials of Dr. McCraney's allegations and any affirmative defenses they alleged. We'll talk about those during jury instructions. 2 is the designated pages from NAMB's motions for summary judgment. They listed out the documents they thought gave the full factual narrative. 3rd is an attorney declaration that talks about the index to some of those exhibits. And then a 4th exhibit is a selection of the NAMB Executive Committee conference call minutes that were introduced into the record. But those were what Dr. Ezell was communicating to NAMB about the facts that were happening there. So let's talk about what those documents say. Part 1, the principal denials. From NAMB's answer, NAMB denied each of the central claims against it. NAMB denied that it tortiously interfered with Dr. McCraney's employment. NAMB denied that it made any false or defamatory statements about Dr. McCraney before or after his termination. NAMB denied that it interfered with Dr. McCraney's prospective business relationships. It denied any conspiracy against Dr. McCraney or any coordinated campaign to damage his reputation. Above all, NAMB denied the coercion allegation at the center of this case, that Kevin Ezell threatened to withhold NAMB's cooperative program funding as a condition of Dr. McCraney's continued employment. NAMB's position was that no such threat was made and that BCMD's board reached its own independent decision to terminate Dr. McCraney. NAMB's affirmative defenses. NAMB asserted the following substantive affirmative defenses. Truth. As to all the defamation claims, NAMB contended that every statement it made about Dr. McCraney was substantially true. NAMB maintained that Dr. McCraney had taken actions inconsistent with the SPA agreement and that its characterizations of serious and persistent disregard and willful and repeatedly accurately described their understanding. Justification. NAMB contended that its actions were justified by its rights under the SPA. NAMB maintained that it had a lawful basis to address what it characterized as compliance failures by BCMD and that its communications were in furtherance of a legitimate contractual relationship. Release. NAMB also contended that Dr. McCraney's claims are barred in whole or in part by the separation agreement he signed with BCMD in July 2015. NAMB argued the release language is broad enough to encompass claims arising from or connected to his employment relationship. Factual accounts on the SPA and the December 2014 letter. NAMB's position was that the December 2014 letter was legitimate, good faith response to genuine compliance issues. NAMB had contended that Dr. McCraney had, over a period of months, taken actions that undermined the joint administration and that its language of serious, persistent disregard and willful and repeatedly was an accurate characterization of the assessment. NAMB's denial of the coercion allegation is recorded in its own governance minutes when Dr. Ezell told the committee his version of the events. That's NAMB's denial in an internal setting. On the lobby photograph, NAMB's position was that posting Dr. McCraney's photograph at the Alpharetta headquarters was a proportionate security measure. Dr. Kevin Ezell stated in a deposition that he authorized the measure because he felt it was a possibility that Dr. McCraney might appear at headquarters in a way that created concern. On post-termination statements, NAMB's positions were as follows: that any characterization of Dr. McCraney's departure as a resignation reflected confusion in the immediate aftermath of the board vote, and NAMB made repeated good faith efforts, it stated, to resolve the dispute outside of litigation through direct means with McCraney, and those efforts failed. On lost employment opportunities, NAMB denied that it took any action to prevent Dr. McCraney from obtaining subsequent employment with the Safari Christian Business Alliance, Jacksonville Seminary, or any other organization. NAMB's position was that its communications with Dr. McCraney, about Dr. McCraney within the SBC network, were limited solely to factual statements made only in response to direct inquiries, and that any decision by those organizations not to hire Dr. McCraney was their own independent judgment without instruction, pressure, or campaign by NAMB. So you have now heard our summary of NAMB's account of what happened, every substantive defense it would have raised in the federal proceedings, and we'll provide you with this binder of materials for your review during deliberations. You may give NAMB's defenses any weight you find they deserve. Move the admission of the exhibit materials for the defense.
And they're included everything that you've noted?
Correct.
In that?
Correct. 4 exhibits, 41, 42, 43, and sorry, PD1, PD2, PD3, and PD5.
Okay, admitted.
Okay. With that, and then the collection of the exhibits we used this morning, I believe we can close evidence and we'll be ready for closing argument.
Should we take a break first before we?
That'd be fine.
Yes, okay. Well, we take 15 minutes maybe, come back at 10:30?